Welcome everybody, my name's Damon. I'm a partner in our trademark group here in Auckland, and I'd like to thank you very much for taking the time to attend or tune into our presentation on the Madrid Protocol. So the format is pretty straightforward. You will shortly hear from our presenters on the protocol and what it could mean for your businesses when it comes into effect in New Zealand on the 20th of December, so about 3 weeks away. Now at the end of the presentation we'll leave plenty of time for any questions that you might have, and hopefully some of you will be able to stay for a glass of wine as well. So I will hand you over to our presenters now. Thank you.
Good afternoon everybody, my name is Victoria Watts, and together with my colleague, also dressed in corporate colours, we are going to be presenting to you on the Madrid Protocol. We're both senior associates in the trademark team here in Auckland. So this is just a little overview of what we'll be discussing today. I'll be running through the basics of the Madrid Protocol, telling you a little bit about what it is and what it does. I will then go on and talk about the differences with the current system of filing trademarks overseas. Amanda will then talk about some of the principal advantages of the Madrid Protocol and a couple of the disadvantages as well. And she'll then be looking at the types of scenarios in which we will be advising to clients that they should be filing under the Madrid system. We'll then go on to talk about AJ Park and the Madrid system, what we can do for you, what our capabilities in this area are, and then, as Damon says, we'll throw the floor open to questions. At this time we will be closing off our live webcast, but those of you who are listening via the internet will be able to ask us questions via our Twitter page, which is @AJParkIP, and we have a special hashtag for this, which is #AJPMadrid. Those will come up on a slide at the end, so you'll be able to ask questions. So, in a nutshell, the Madrid system will enable trademark applicants here in New Zealand to file a trademark in New Zealand that may end up giving you protection in a large number of countries overseas. This should ease the administrative burden of filing trademarks overseas and may result in significant cost savings to you. So a bit of history. The protocol is in fact a protocol to the Madrid Agreement of 1891 on the international registration of marks. Now, the Madrid Agreement was entered into by a core of European countries, very few to start with, and it was quite restrictive in its scope of what you could do. For a start, all applications had to be filed in French. Many countries felt that they couldn't deal with this system with their current national legislation, and so couldn't enter the system despite some of the advantages it was bringing. So in 1989, the protocol to the Madrid Agreement was signed, and this came into force in 1996. Since then, a large number of countries have joined. The system is far more flexible. You can, for a start, file in English, and since 1996 you can also file in Spanish as well. So after history, a bit of geography. It is a system that covers a large percentage of world GDP. It is rapidly expanding, and indeed just yesterday WIPO published notification that Mexico had acceded to the treaty and would be joining in 2013. So other than New Zealand, there are new countries coming on board all the time. Other than New Zealand, this year we've had the Philippines and Colombia. India is due to join in January 2013, and in Thailand they've also acceded and they will be joining in 2014. So ever more countries are coming on board. The system covers many important export markets for New Zealand, including the US, Europe, Korea, Japan. It also covers sources of competitive and counterfeit products. So it's an easy way to get coverage in those countries, and those include Turkey, China, Russia and Ukraine. There are some notable absences though. It doesn't cover Canada, Hong Kong is not a member, and the majority of South America is yet to join up. But the World Intellectual Property Office, who manages the system, is always sending people overseas to these countries to try and encourage them to join. So an international registration is a registration that has effect in the number of overseas countries that you have designated, either at the time of filing or subsequently. It can be thought of as a bundle of national registrations. To file an international application that becomes an international registration, you need a basic mark. Now, as New Zealand will be joining, we'll be looking at things from a New Zealand point of view. So to file an international application through New Zealand, you will need a basic mark in New Zealand. Now, one of the things that the agreement did was said that you had to have a basic registration before you could start. The protocol says that you can have an application in place. It doesn't need to have progressed to a registration before you actually file your international application. So what this means is you don't need to file a new application to take advantage of the international registration system, but you can look in your portfolio and see that there's a mark that you're still using that's current, that's many years old. You might want to base your international registration on that. Conversely, you might file a trademark today here and file an international application tomorrow on the basis of it. There are good reasons why one might not do either of those, and Amanda will touch on those a little bit later on. Now, 5 years after filing, for 5 years after filing the international application remains dependent on the national mark. So this is this 5-year dependence period. After that, during that time, if the national mark is for some reason successfully opposed, limited, cancelled, then the international mark will be limited to the same extent. If after that time it becomes completely independent, and it is possible to limit the national trademark, to allow it to lapse, to assign it to somebody else, and that won't affect the international mark itself. A national designation is basically what you get at the end of the filing system. So when you file a trademark application in an international application through New Zealand, you would designate a number of countries and territories. These are the countries and territories into which a trademark owner wishes the protection of its trademark to flow. Now, I say countries or territory because the EU as a whole has joined up. The EU is one of the places you can designate as a whole. I will go on to a slide in a minute which actually shows you how that works and how the national officers will deal with those national designations. There are still some restrictions on who can file an international application. Again, since we're dealing with New Zealand, we'll talk about the system from New Zealand. So to file an international application through New Zealand, it's necessary to be a national of New Zealand, domiciled in New Zealand, or to have a real and effective commercial or industrial establishment in New Zealand. Now, that last term is a little bit vague and nebulous. It is something that's discussed under national law in each country, but safe to say that if it's a limited company in New Zealand, then it will be entitled to file a trademark, an international trademark through New Zealand. So this slide points out the differences between the current system of filing trademarks overseas and the Madrid system that we'll be able to take advantage of from the 10th of December. So at the moment, when a client instructs us to file overseas, we will enter into contact with an overseas agent. We will instruct the agent in English, and they will liaise with their overseas office and file the application in their local language. So if we're filing in 3 countries, we'll deal with 3 separate agents, and they will deal with 3 separate overseas offices. If there are problems, either at the time of filing or later on during examination, the overseas office will write back to the agent in the local language. They will translate for us, and we will liaise with you to take your instructions to deal with the problem. When we are looking at filing through the Madrid Protocol system, this is the far slide, we will be filing an international application directly through IPONS, the Intellectual Property Office of New Zealand. At that time, we'll be designating a number of countries that we want to file the trademark into. And just as an aside, the average number of countries, according to the statistics that people file into, is 6 or 7. So you might be filing in quite a number of countries. IPONS has a very important role to play in that it will certify the international application. It will certify that the owner is the same as the basic trademark, that the trademark is the same, and that the goods and services are the same or narrower than those covered by the basic mark. Once IPONS is happy with this and it's certified those three things, it will send the application on to the World Intellectual Property Office in Switzerland. It's based in Geneva, otherwise known as WIPO. WIPO will also carry out an examination of the trademark. It will look to see that the formalities have been completed correctly, so that there is an address for service, that there is an address of the applicant. It will also check to see whether the specification conforms to the WIPO rules on classification. If there is an issue, it will raise it with IPONS, who will in turn raise it with us. Once WIPO is happy with the trademark, it will issue the certificate of registration, it will publish the trademark in the Gazette, and it will importantly notify these overseas offices that have been designated in the original application. So it's WIPO that deals with these overseas offices, and again it will deal with them in English. So whether it's writing to China or the US, it will always be in English. If there is a problem with these overseas offices, they will then look at the trademark according to their national law. So the Madrid Protocol and the Madrid system is a procedural treaty. It doesn't affect the way that overseas offices actually examine the trademarks. So they will examine the trademarks according to their national law. If there is an issue, they will raise it in English, again, with WIPO, and WIPO will correspond with us directly. So it cuts out a layer of agents in the initial application stage. If there are no problems, then we may not need to appoint an agent overseas at all. If there are problems, then in order to deal with those problems, we will normally need to appoint an agent. So the agent will then slot in here at this level. I'll now pass over to Amanda, who will talk to you about some of the advantages and some of the major disadvantages of the Madrid system.
Thanks, Victoria. I'm going to go through how Madrid can benefit you. One of the first advantages is that it really simplifies the procedure when you're filing overseas, particularly where you're wanting to cover a lot of countries. So as Victoria's outlined, what we do now is when you want to file overseas, we appoint agents in each of the countries that are of interest to you. With Madrid, we're filing one application with IPONS. It's in English, so you're not incurring all those translation costs, and there's no need to appoint an agent at that stage. You'll find that at the moment you're probably having to sign quite a few documents like powers of attorney, and that's how exciting powers of attorney are. They can drive you a bit mad, particularly where they have to be notarised, legalised. It can be a bit of a pain. But with Madrid, there's no documents to sign. There's one exception to that. That exception is the United States. If you want to designate the United States, there is one document you need to sign. It's just a one-page form. You just need to sign and date it. And that document is to say that you have an intention to use the mark in the United States. And we just file that document together when we file the international application with IPONS. But apart from that, there's no other documents for you to sign. One of the principal benefits for Madrid is the cost savings. There's going to be upfront fees for filing the international application, and there's also going to be fees for each country that you designate. With a Madrid application, it doesn't automatically cover every single country that's a member. You have to designate which countries are of interest to you, and there are costs attached to each of those countries. On average, we believe that if you're designating 3 or more countries, it will be cheaper for you to go through the Madrid system than it will be for you to go and file national applications. If no objections are raised, we don't need to appoint agents in any of the designated countries, so that is removing that additional layer of costs as well. There's just a few things to note about costs. The first thing is there's no real formula for Madrid in terms of cost savings. It's not going to save you 20, 30, 40% or an X amount of dollars. It's really a case-by-case assessment. And what we'll do is when we give you cost estimates for filing through Madrid, we'll give you a fee for Madrid, but we'll also give you an estimate for filing through the national system, so filing national applications as well. So you'll be able to compare what the costs are of the two approaches and see which one benefits you. Another thing to note about costs is that IPONS, as the Office of Origin, so as the office that receives the international application and passes it on to WIPO, they have the opportunity to charge what's called a handling fee. IP Australia charge a handling fee of 100 Aussie dollars, but IPONS has decided not to charge anything at all, which is good news. But there has been a bit of press in the last couple of months saying that it doesn't cost anything to file Madrid, and that's actually incorrect because you still have those upfront fees for filing the international application, and you still have those fees for designating each of the countries of interest to you. Another big benefit of Madrid is something called subsequent designations, and that means that you can designate or add a country at any time to your international registration. The cost for doing that is quite a bit cheaper than if you had to file national applications, and it becomes more important as more countries are coming into the system as well. So for example, if you decided to file an international application next month when it comes into force in New Zealand, but the only export markets of interest to you are the United States, China and Europe, we would file an international application designating those three countries. But say in 3 or 4 years' time more export markets open up to you and you want to add countries like Singapore or Colombia, then we would file an application to subsequently designate those 2 extra countries, and they form a part of that bundle of national rights through Madrid. The priority date for a subsequent designation is the date that you file the application for a subsequent designation. It's not the date of the international application, the date it was filed through IPONS. So there'll be you'll have some countries which have a few different dates with them. However, when we're renewing an international registration, the date of renewal for the international registration and the date of renewal for the subsequent designations are all the same. So you may have a situation where you need to renew an international registration and the month before you decide to subsequently designate another 10 countries. When it comes time for renewal, the next month, you'll have to renew everything, all the 10 subsequent designations plus whatever's been designated originally. Another advantage is that it really simplifies maintenance of your international registration. So international registration is due for renewal every 10 years, and what we do is that we just pay the renewal fees to WIPO. We don't have to appoint agents and pay agents for every country that you designate, so it's a lot cheaper, a lot easier to renew. And again, you're not having to sign lots of forms as well. Likewise, when you're recording assignments, changes of name and address, it's a lot simpler and easier to do this because you're just recording this against the international registration. You don't have to appoint agents to undertake this task for you. There is a couple of downsides to Madrid, like anything. There's an upside and a downside. The main disadvantage is what Victoria's also mentioned, which is dependence and central attack. So the basic mark, the international registration will be dependent on the basic mark for 5 years. If you have a weak basic mark, it does leave you open to something called central attack. And central attack is where the basic mark, it lapses, or a third party opposes, invalidates, revokes, cancels, or tries to limit your basic mark. If that happens within that 5-year dependency period, then your international registration will also be cancelled or limited. So essentially your international registration could fall over. Luckily, central attack's not used that often, which is good. If it is, it's not the end of the world because there is an option called transformation, which means you can transform your international registration into national applications and registrations. Another disadvantage is with assignments. You can only assign an international registration to someone who is entitled to hold an international registration. So at the moment, Canada is not a party to Madrid, so you wouldn't be able to assign your international registration to a Canadian individual or a Canadian company. but hopefully this is a problem that will ease over time as more and more countries come into the system. The question that's really big for all of you is will Madrid work for me? We're not going to recommend that you file Madrid in every single instance. In most cases, it will be a simple and cost-effective way for you to protect your trademarks overseas. However, it is a case-by-case assessment. This flowchart up here just sort of looks at some of the questions that we would discuss with you to see if Madrid is the best option for you and your business. Some of the instances where we would recommend filing through Madrid would be if you have a really strong basic mark, so it's in use, it's not vulnerable to attack by third parties, it's the correct mark, and it covers the goods and services that you want it to cover. Also, if you're trading in a large number of countries and those countries are covered by the Madrid system, and if counterfeits are a problem for you, you have countries like China and Turkey, which are members of the Madrid system, and by filing Madrid and designating those countries, you can easily protect yourself against counterfeits. The instances where we may not recommend that you use the Madrid system and instead file national applications is if your basic mark is under threat, so there may be an opposition or a cancellation, because that leaves the door open for central attack. Also, if your mark is potentially descriptive, so there may be issues in some countries due to language, it may be seen to be descriptive, then it may be better to file national applications. So there's a few issues to think about, and we'll work with you to decide, which issues are really important and if there's any problems for you, and decide which option is the best option for you.